Chris Buck, and he is running for the newly created 457th District Court in Montgomery County. It's November 21st, 2019. With me is Dale Fessenden, Larry Rogers, James Byers, David Smith, Dennis Tibbs, and Pat Tibbs. And so as we discussed, we will, Chris, if you want to get us started, and you have about 5 minutes for your opening.
Sure. Like I said, I won't probably take that full 5 minutes. It's a civil court, and I am a civil lawyer. I've been doing civil and litigation for my entire career, which is coming up on 12 years now. I've been an attorney for 11 and a half years, and I started off as a, like most young lawyers do, working for other attorneys and an insurance defense firm, and doing the grunt work, the investigations, the discovery, the motions practice, learning how to litigate cases on a day-by-day basis. After about 5 years of learning from other people, I kind of, probably a little earlier than most, started my own firm. And for the last 7 years, that's what I've done, and that's gotten me into a lot of courtrooms. And today I'm in the courtroom 3, 4, 5 days a week. Oftentimes at least 3, most of the time 4, and sometimes 5. In addition to that, the last couple of years I've been asked to do some appellate work, and so I also handle appeals. And so I think for the voter, what that means is not only am I in court all the time, I review the work of courts, obviously for a client, but I have a good idea about what the good courts do well and what the poor courts do poorly. And ultimately, I can see what kind of procedures and processes that the good courts have, and have the ability to emulate those if I'm fortunate enough to be this public servant role. And that is how I feel about it. It is very much a public service role. I think when I get asked about why I wanted to run for a judge, I think that's kind of my background. My dad was a police officer for 27 years, grandfather a fireman, a couple uncles are firemen. There's, public service in my whole family tree. Family friends are police officers and firemen. I somehow became a lawyer. So that little bit of public service kind of influence never really went away. And so a few years ago I started thinking about it, and I kind of decided that's what I wanted to do. Of course, here living in Montgomery County the last 11 years, I wasn't going to run against an incumbent that I thought was doing a good job. And so when this newly created civil position got created, I asked around the courthouse from some people that practice a lot, and also had been in and around Montgomery County politics a little bit, and I asked them, hey, what do you think about this? This is what I'm considering. And frankly, none of them said, that's a terrible idea, Chris, you should never do it. So I did decide, after a lot of consideration, because I know that running for a judge or any political office in a campaign takes a massive amount of work. And I saw that firsthand because when I initially started my practice, I did a lot of work in Montgomery and Harris County. So I started off initially about 3/4 of my work was Harris County and about 1/4 Montgomery County, and nowadays that's flipped. But given that those judges down there had some very contested races with the Democrats, I had helped a number of them on their campaigns, and so I knew how many events and dinners and meetings and just the amount of time it took out of your schedule. And I have a wife and a 12-year-old and a 9-year-old at home, and so I knew that I didn't want to jump in this if I wasn't sure about it, because it was going to be a strain on them, even if it is just for a matter of months while the campaign is going. So I carefully considered it, and while I was carefully considering it, I paid attention and kept waiting for someone with, say, 15 or 20 years of civil litigation experience to put their hat in this ring for a civil court judge. And nobody did, and so knowing my experience, I thought I've got just as good, if not better, experience than the people that are in the race, and so that's why I decided to put my name in.
So is that the key differential that you see? Well, thanks for that overview, and thanks again for coming in.
Sure, I appreciate the time to talk to you guys.
Yeah. So is that the key difference that you see right now between you and your opponents, is that your civil experience as opposed to the other two or three?
Now, that's the tricky thing, because I'm only really aware of the other two. I know one of the newer opponents. I don't know if I'm supposed to say like names or anything like that. trying to do this the right way. But yes, dealing with just the two that were in there when I applied, I did feel like I have something to offer, you know, the other citizens of Montgomery County. And I've been here 11 years. Actually, I was thinking about it. We closed on our house on the 18th of November, so we've been here 11 years this week. So, and I really felt strongly that my civil and litigation experience and experience in a courtroom, in a civil courtroom, was a differentiating factor that I felt like I could at least offer to our voters.
So how much of your trial experience do you think will weigh in on this versus the other two candidates? It seems like you said you've been in the courtroom almost 5 days a week in a lot of cases.
You're asking about how my trial experience will affect the candidacy, or what I would do as a judge?
Right. Both. Your candidacy and as a judge.
Well,
and what you have to deal with.
Going back to some of the questionnaire that we filled out, I think one of the question was one question that jumped out at me was how voters are able to get informed about you and just get informed generally. And with kind of this day and age, there's a lot of misinformation out there, whether it's media sources or social media, things like that. I think the best thing I could say to kind of bring it back to your question is do everything I can to inform the court about inform the voters about what this court and what this role is going to request of the person who takes that seat. And that is very much experience in a courtroom and handling cases and understanding how to move cases efficiently to resolution, while being as efficient as possible with taxpayer dollars, but at the same time, if the voter, the citizen wants or needs to have their day in court, giving them their time, listening to the evidence, and giving them a timely ruling that fits within the parameters of the legislative law. I hope that answered your question.
Yeah, it did.
Thank you.
Thanks.
Okay, I guess I'm trying to get a clarification or a better understanding of your courtroom experience, because in one of your answers you mentioned 3 jury trials. Is that the full extent of your courtroom experience, is 3 jury trials?
No, jury trials are kind of, in terms of having jury experience, they're kind of hit and miss. There are lawyers that can go a career and not have one, or just have 1 or 2, and then there's some that seem to get 2 or 3 a year. There are a lot more criminal jury trials, and I've never done criminal and civil. And civil jury trials are fairly rare. They say 95% of the cases settle. Truthfully, that's probably an understatement a little bit. In addition to that, just because that 5% doesn't mean they go to jury trial, a number of those go to bench trial, and then a number of those go to a bench trial or a jury trial with only 1 or 2 questions for the jury, rather than the whole gambit of what was asked at the beginning of the litigation. And so, I think I answered that as well. I've had over 150 bench trials, and numerous along the way before you get to the bench trial. You're going to have contested hearings contested evidentiary hearings where the rules of evidence apply, people are sworn in, and those are really and truly the hearings and the things that take a judge and a court staff's time the most, is the evidentiary hearings that they hear weekly and daily, whether it's a motion to compel discovery responses, or to exclude witnesses, or sanctions, or without getting too much into the nitty-gritty of litigation, those are the things that the judge is hearing and calling balls and strikes on for people so that they can move their case along to a resolution.
Okay.
And I hope I answered that right.
Okay. And a real quick question, since I have limited time this time around.
Mm-hmm.
You have your own firm. How many lawyers are in your firm? Are you the only one?
I'm a solo practitioner. You're looking at the CEO and the janitor. So.
Got it. Okay, Larry?
Okay, so your private practice has been here in the Woodlands for the 7 years?
My office, I initially started off office sharing with some mentors, and they were in Harris County, and then 5.5 years ago I moved my office to Conroe Tower in downtown Conroe.
Okay. Why do we really need this 457th court? Why is it all of a sudden come up?
I think The answer to that is that there was a backload of civil cases. There are a large number of cases, and one of the decisions I made before really jumping into this race, I did go and talk to a couple of judges and talk to some people at the courthouse and say, you know, what's going on? And right now there's one civil district court, the 284th, and it's overloaded, and it has, I think it's had, I've been there, it's had 2 jury trials this month. And as a result, other judges are having to cover some of the civil work. And so there is very much a large docket of civil cases in Montgomery County. I think part of that is that kind of the secret is out in our community. I live in the Woodlands 5 minutes from here. My wife and my kids, we love it. People, you talk to people who live in Lake Conroe, they love it. River Plantation, they love it. Problem is, they keep telling everybody they love it, and people keep moving up here, and unfortunately, you've got infrastructure and things like roads and things like that need to kind of improve to meet the needs of the growing public and the court system. I think the last time a new court in Montgomery County was added was 2008, if I recall correctly. So it's been roughly, this will be 12 years, and the population will almost have doubled in that time. And so that's kind of the basis for it, I think.
Okay.
Sorry if I beat up your time.
Credit card cases, have you ever had any, plaintiff or defendant, doesn't matter, have you ever had any that you represented?
Simple credit card cases? No, I have not.
Now, if you ever sit in any of these courts and watch, and 457th will be par for the course certainly, most of those are at least the defendant pro se. Now, we know that in Texas, it's where judgments come to never die.
Right.
They don't have to expire, unlike, I think, maybe every other state. So your credit card companies love to come here to file suit, and 90% of them do have no appearance by the defendant.
Sorry.
And I'd say majority, go ahead.
I didn't catch what you said just then, so I want to make sure I got your wording right.
Which part?
The very last sentence you just had. Credit card companies come here to file suit. And
Yes, and most of the defendants are pro se.
yes.
Okay. And then the problem is, of course, as judge, you're sitting there, you have a pro se litigant.
Which means what for the camera, per se?
They're not represented by an attorney.
Yes, thank you. Correct. They represent themselves.
Yes.
And they probably are a little spotty on the law and probably, of course, very ignorant of the rules of procedure for that court.
Yes.
And we know there is no consistency from one court to the other on rules of procedure. There's not. So my question is, as a judge, what is your obligation towards the pro se defendant? Because, you know, the plaintiff will do what they need to win their case.
Right. The obligation to the pro se defendant is to make sure that the process is as fair as possible. At the same time, there are very clear rules by the Bar Association that the court or the court staff cannot give legal advice.
So no legal advice. And
Right.
what about process?
The key that but fortunately for Montgomery County, we have a law library with a reference attorney. And there are also, depending on the nature of the pro se, whether it's a veteran or female, there are different community resources that you can refer them to. So being
That would help them with the law.
Yeah.
But once again, the process, the rules of procedure, that's not in the law library.
Right. I think in some of those situations, and it's hard to do it without a fact-specific case, but
Sure.
I think the judge can, well, I hesitate to use the word advise, but to inform them as clearly as possible of what the procedures are for their courtroom. And the key on most of those procedural things is deadlines. And so
Let me give you a clear example. Understand that the issue here, it is kind of broad. Let's say that a pro se defendant did actually have a very detailed answer to the plaintiff. They raised a number of issues, venue, the contract, the list of charges and all of that. Then the plaintiff files a motion to dismiss, and the pro se defendant doesn't file an answer to that motion. What would you do as judge in that case? And let's say that the answer does exactly exist in the defendant's original answer. They just didn't file an answer to the motion to dismiss. What would be your obligation there? Would you fine for the plaintiff for lack of prosecute or what?
Well, the first thing is whenever someone brings a motion and asking the court to do something, you got to review that, and then you
Sure.
familiarize yourself with the area of the law. And if the law, look, I am the first one to say judges should not legislate from the bench. If the law is what I would call a shall statute, which means it requires the court to go in a certain way, then you follow the law.
Sure.
If there is judiciary discretion, which
Well, what about the case example that I gave?
I'm assuming there's discretion that you're talking about. That's what I was getting to. And I'm being a lawyer here.
Well, all right, I'll digress. I know federal law has already ruled on this from a due process standpoint, and federal judges, by case, do have to look at the entire body of what's been filed at were pro se,
Right.
and not worry about the manner in which the answer was given. I'm just wondering, are you going to go against that or not in your district court?
I think what I'm picturing is there's a credit card case brought by plaintiff, answer, detailed one, that does address a number of issues.
Yeah,
A motion is filed
on one of those issues
on one of those issues that
the defendant addressed.
so even though the pro se defendant doesn't specifically respond to the motion, their
Yes.
original answer is responsive to the
That's the situation.
Gotcha. Sorry about that. Okay. I would definitely brush up on if there is a shell statute. If it's within the judicial discretion, I would likely, in the case-by-case basis, inform the petitioner that a response to your motion was included in their answer. And that would be most likely where I'd go.
All right, just a real quick one, I know I'm over. Let's say in that same case, at the day of trial, neither the plaintiff nor the defendant appear. How do you rule in favor of what party?
Typically, a day of trial, they would
Neither party appears.
They would most likely get dismissed on that type of case.
In prejudice against whom? Which party would lose? The plaintiff or defendant?
Technically, in any kind of a case is dismissed, the plaintiff technically loses, but just because if it's dismissed for want of prosecution, it is not dismissed with prejudice, it's dismissed without prejudice. So they could have, if they're within their statutory deadlines, refile the same thing. It happens quite a bit, particularly in not only in civil, but
No, the
law and family.
refile, do they have to give an excuse as to why they didn't appear as plaintiff?
No, but they have to repay the fee. That.
I see what you're saying.
Yeah.
And if the defendant does appear, do they get the same opportunity they can refile to defend?
They don't need to.
Sounds
refile.
pretty unfair to me.
They don't need to refile to defend. And an answer.
So they file a motion to review?
Who?
The defendant that didn't appear.
I don't think they would want to. If they literally. So what I'm picturing is the plaintiff has filed affirmative pleadings, specifically
Yeah.
asking for the court to make rulings.
Right.
Defendant has just said no and general denial, but they're not affirmatively pleading for anything themselves. They have nothing to refile on. And if the plaintiff refiles the case and properly serves them that same answer with no fee, the answers have no fee, filing fee for that. So
Now you can see how complicated the procedure, not the law,
that's right.
is for pro se. And judges do have responsibility there.
Sure.
Go ahead.
Sure.
Okay, David.
But again, referring to as many resources as you can would kind of be and having a staff that does
Sure.
that is kind of be one of my points on that.
Okay.
Yeah.
Do you have a question, Dave?
Let's see how many parts. Let me add them up first. So I'm going to move more philosophy type answer.
Sure.
So this week the House of Representatives, Democrats, renewed the Patriot Act. This act was used to spy on candidate Trump and President Trump. They wiretapped them, and so we now have the last 10, 15 years this conflict between privacy versus surveillance, government new. And we have a county sheriff and Sheriff Henderson who loves installing cameras.
Mhm.
You know what I mean?
That's
And
correct.
he'd like to record it. Well, I'm looking for the camera in this room. But, so we have a privacy issue, and the EU has a law called the right to be forgotten, right, applying to that, and we have the need for government surveillance. How do you balance that as a judge?
As a judge, That's a good question, and to put it as a judge, I can be more comfortable answering you as a citizen. Does that help you at all?
Oh, no, it's a philosophy question, so
Right.
we're not looking at legal
Yes.
structure, we're looking at philosophy, you know, citizen.
I can tell you that I was very much against the installation of all the traffic cameras in the woodlands, and I feel like the privacy, it's hard to just create a test out of thin air. If you're looking for a word you come out on. I tend to lean towards, when in doubt, privacy prevails. Hard to give you kind of a, like I said, hard to give you a kind of a clean test of how I would balance that as a philosophy. Obviously, there is due process, and that's kind of with technology growing, I think, is where you've seen the growth in surveillance and the ease of surveillance. And it used to be that they didn't surveil everybody because it was just too expensive to do it. Now it's so much less expensive and it's easier to do. And on the balance of that, for the privacy, that's obviously the expense of it. I mean, you improve your surveillance, the expense is privacy, and if you don't have the due process standards in place, people's liberties are going to be taken away. I saw an article this week on front page of, I can't remember what it was, that someone was arrested because she was topless in her own house. And someone's camera or someone's vision got that. Obviously, in that situation, the surveillance and it has gotten a little bit out of hand in that regard. So it's to go with the classic punting of the question is, you kind of know it when you see it, when the surveillance has become too much for the personal liberty. I wish I could give you a better test like that. If I had time to kind of read up on it, I probably would give you a better...
Well, I have a joke that goes along with that. It's my understanding that the judges in Montgomery County, including this one for 457, has more to do than hear cases. And it's my understanding that they have a rotating shift where every judge has to administer grand juries and every judge has to be on call certain nights and weekends to issue search warrants.
Mm-hmm.
So, wondering about search warrants. Are you familiar with the case of Drake Pardo, a little boy who was taken by CPS because his parents wanted to, their doctor wanted to have some sort of treatment, and CPS somehow got involved, and that doctor wanted to do something different, and they taken him for about 8 months. And in fact, there was a legislative session this week in Texas trying to review what the CPS did.
Right.
So I guess the question is, somewhere when all that stuff happened, some judge issued a warrant to go pick up that little boy. So if that's you, how would you look at that, and where would you get the information? How long would it take you to make the decision, and are you prepared to look into something like that?
Well, starting my practice, I've kind of focused on civil and family, and one of the family areas I do a lot is child welfare law and CPS area. And what a judge issues when they go pick up a child is they grant the Department of Family and Protective Services temporary managing conservatorship or emergency temporary managing conservatorship. And the standard on that is, in the law, is whether or not, by clear and convincing evidence, the department has shown that a significant emotional or physical well-being of the child would be, significant impairment to the physical or emotional well-being of the child would occur. I don't know the specific details as to why that child was picked up. I think if it's simply because a doctor wanted to perform a different medical procedure,
That's all it was.
I'd have some very serious questions for how that court came to see that evidence rising to a significant impairment to the physical and emotional well-being of the child.
Part of the reason is because they, according to the documentation, never ever interviewed the kid, never interviewed the parents, never firsthand interviewed any doctor who had seen the kid. It was all promoted by CPS.
Right, and there is a problem with those CPS. When they initiate a case, they file a formal pleading, but when they do is they attach a an affidavit to it. And there are problems with those affidavits, massive problems with those affidavits, and they are waiting. And it's gonna catch the right lawyer's eyes, and they are gonna get hammered in this state for the way they do those affidavits. Because at the top of every affidavit, it says that the following is in my first-hand knowledge and is true and correct. And I swear to it under penalty of perjury. And then they load it up with a ton of hearsay. It is reported that, it was alleged that. And that's the core problem. I think that would be my guess, is the starting point of the problems in a case like that.
Well, that's sort of the same issue that we have with the FISA warrants that are in the news every day. And whose job is it to check that stuff and disbar those people or put them in jail or do whatever needs to be done to stop this stuff from happening? In Texas, whose job is it?
Well, if a court is reviewing it, I think they would look at the person making the statements under oath and saying, are you sure? You've got to double check and say, are these within your first-hand knowledge? Are you swearing that they are true and accurate? You know, and then if they lie, and they find out later that the judge finds out later that that person lied to them, they need to refer it to the criminal prosecution. So,
Well, what you described was clear on the face of it that it was a lie.
what I described, or what you described?
They swore they knew it firsthand that all they had was hearsay. Why would you send somebody like that off to jail immediately? The
Well,
CPS person that signed it.
Immediately, because they also have due process rights. Isn't it just like, you know,
They're there, judges there, court's in session,
right?
do the due process. You go to jail, right?
I don't think so. Not exactly. I think they do have a little bit more. They are allowed time to prepare for trial, have counsel,
Sure.
that kind of thing. So.
Well, would you refer them for prosecution?
Yes. I mean, if I found someone swearing on an affidavit in my court that was something that was not true, absolutely. That's a no-brainer.
So the judge is the initial test. So people bring an affidavit or an application to you, you will quiz them about it and ask them and make sure they're doing more than pencil whipping it.
A judge has a duty to do that, yes.
Switch gears a little bit here. You were asking for the Republican nomination, and the question was, what have you done to get back to the GOP? And you said over the last 5 years, you have personally and financially supported campaigns of several GOP candidates, and who would that be?
Like I said, a number of judges that were facing strong Democratic challenges in Harris County. I apologize, but I can't remember who exactly. I'm pretty sure, confident I've paid financially to all these people, but I know I also supported them and appeared at polling stations in my hometown of Tomball for a number of these, so that I could shake hands and hand out and wear their t-shirts and recommend that they vote for these individuals. There was Judge Farr, Judge Moore, a candidate, there was a friend of mine, Phil Playcheck, who ran for the nomination and ultimately dropped out because of Alicia York, who I then supported also, and she became Alicia Franklin. She was Alicia Franklin as a candidate, got married, and it was Alicia York as a judge. I also supported the campaign of Mecca Walker for the Republican nomination, as well as Charlie Prime, Sherry White Dean, and I'm honestly probably forgetting a few. Those Republican judges in Harris County were facing steep challenges the last, several election cycles, and I wanted to help them. So.
Okay. Finishing my note there. We already mentioned briefly the part of the case. Are you familiar with the James Younger case?
Doesn't ring a bell off the top of it.
7-year-old boy, divorced parents. It's become pretty top headlines.
Okay, I have not seen, I've been buried in my own child welfare law stuff as well. So.
Okay. And that's just one example, but it has cropped up a number of times where in this case, again, it's a child custody case, a specific issue which I don't want to take the time to describe, but both parents have been, had a gag order levied on them by the judge.
Okay.
They're not allowed to discuss the case. what is your opinion of gag orders? I've seen all sorts of discussion. I'd like to know what your thoughts and your position is.
Well, going back to, in a civil case, in a true civil court, I don't think they're going to come up as often. Usually they come up more often in family cases and criminal cases. Criminal cases, it's usually, they don't want people discussing the facts to the public to taint a jury pool of some kind. In a family matter, they don't want, they certainly don't want parties discussing the case with a minor child. And they also oftentimes don't want the confidentiality of minor children being expressed to the public as well. In a civil case, I don't see it happening very often. If it's necessary to protect a child, I can understand an order that they're not supposed to discuss it publicly, or particularly the issues that are sensitive to the minor's medical care, things like that. That's kind of where I'm kind of envisioning some of those issues might be that you're trying to get a feel for. Am I totally missing your answer?
No, that's pretty much on track. But the issue had already risen, as I said, to a pretty high level of visibility, as a matter of fact, around the country.
Right.
I mean, this was national news.
Sure.
And obviously people like me, when they see the issue brought up there and we have certain opinions on that, we'd like to be able to follow that, know about that, and so forth.
Sure.
And so it seems like it's contrary to the First Amendment in that context.
The free speech, effectively, the gag order is a limit on free speech to...
It's a gag order on the parents.
Right. I think, the classic line in law school is that free speech ends where someone else's personal safety begins. So, you can't yell fire in the crowded, theater, which it's kind of the classic line. I'd have to see what kind of a challenge, what the language of an appellate court might be if that was challenged on a free speech basis. That'd be an interesting question for as a legal philosophy, very interesting
I
question.
want to read up on that case
Yes.
because I suspect you.
Sure.
Yeah.
Come
That's
across
the one where his mother wants a sex change?
Mhm.
No.
It's one or two.
On a 7-year-old boy.
that one. I didn't recognize the name. I recognize the subject matter now. Just
Okay.
I didn't recognize the name. So
Okay.
I got it now.
James Younger.
Yeah.
Okay.
That's the 7-year-old boy.
Right. The subject matter, totally with you now. I've seen it.
So you think a gag order is appropriate in that situation?
The trick on that is the court could be aware of some factors that are very sensitive to the child's medical well-being and personal privacy. And I think the answer is it's hard to say. You have to know what the judge knows a little bit. If there's something that, look, at the center of that, and that's a crazy case. Step back and just say, it's a crazy case. At the center of that is a child. And probably that's where these judges come back and they say, okay, how do I protect the kid? How do I protect the kid? And it would be difficult to just say the judge is getting this completely 100% wrong without knowing exactly the things that have been said to him privately, because the judge can also interview a child privately. And allow the child to speak freely away from the parents so they're not being influenced, and you certainly hope that he did that, or she did that.
Larry?
Okay, we've determined that why we need this court, there's an overflow. Have you given any thought to, or research as how many staff members will you need to run that court? Do you have any idea?
I think it would be a very similar setup to what the 284th has now. They have two of the staff members, and I spoke with the district clerk about this because I investigated what they were going to do, and two of those staff members belong to the district clerk. One of them will be in an office in the courtroom, and the other one will be in her office assigned to the court to handle the electronic filings that come in constantly. Things like that. So that's two, and that's kind of already been budgeted by the county and already accounted for, and that's how they handle those types of, the clerk handles these types of courts. In addition to that, district courts in the state of Texas have a court coordinator that's funded, that position is funded by the state of Texas. In addition to that, there's the Sheriff's Department has a bailiff in each courtroom, and a court reporter. And I believe in a civil district court, they have a briefing attorney to assist with complicated legal matters, so that while the judge is on the bench handling your day-to-day process of moving cases along, someone is able to research the more complicated matters or questions that the court might have. Because let's face it, no matter who the judge is, if they're a first-time judge, they are going to have to work hard to continue to learn day by day by day
Sure.
by day. And that is something that hasn't been in the courtrooms, and letting the judges know, because that's one of the things I did, is go meet with each judge and let them know that this is what I wanted to do.
Along that same line, apparently that one of the reasons for the caseloads is that apparently some judges seem to not have a full work day or full work week. What would be your hours for the work week?
The key is this court is probably going to be, this is going to get very practical. I anticipate this court being located right across the hallway from the 284th, the other civil district court. Now, it might seem like a really good idea to have, if the 284th has a 9 o'clock docket, to also have a 9 o'clock docket, but typically that means that this side's waiting for lawyers in this room, and this side's waiting for lawyers in this room. And so to have one that's maybe 8:30 or a little bit off, so that you can get the people that need to be in front of you in time. I would anticipate that the court should be open for regular business hours at all times with a staff member, with multiple staff members starting at 8 to 5. And in addition to that, I've been in courts where I have tried to call and see if something has been signed by the judge, or can I get a hearing. And I've called over the course of 2 or 3 days and gotten nothing but dial tone, and I cannot get a hold of someone, and that takes a long time. And that is something that flat out irritates you as a lawyer. I know it irritates the parties, because I've spent 45 minutes or an hour over the course of 2 days, and they've gotten nothing for it. And so I fully understand that frustration. And so simply keeping a full-time work day, and also organizing your staff in a way that it's simply, hey, we take lunches at a staggered time so that the phones can be answered. And if someone comes to the court and asks a question, there's someone here that can answer the question. And so a very simple, straightforward, common sense approach to that is kind of how I would take it.
5 days a week?
Yes. On the dockets, I think I did that in my answer.
Yes.
Regular dockets, 4 days a week.
4 days.
I think some of the smarter courts reserve, not that they're not going to be there on the 5th day, they hold it open because they recognize that on Monday at 9 o'clock you had a couple of lawyers come in and say, we've got this issue, this issue, this issue, this issue, and you look at the counsel and you say, how long is this going to take? And they say, I estimate 2 hours. And the other guy says, I estimate 3 hours. Well, you don't want to handle 3 hours while you got a courtroom of people waiting. And so you say, how about come back on Friday at 10 o'clock at this specific time, and we're going to handle your case right then, and then you move the rest of the docket along efficiently.
Great.
So,
Thank you.
You know, with the motions that are filed and everything, I'm always amazed that if you already have documents in writing from both parties that address the issues, everybody's filed and answered, made their case citations or should have, and that sort of thing. Why do we still have to have a physical appearance? You just described lawyers in one courtroom being conflicted, they have to go to another courtroom, and these delays. Why on earth can't the judge yourself rule based on what is written and issue your opinion? Why do you need the people to show up anyway?
I think in some cases you could. Now,
I don't know of a single case that's happened. Now, I don't know all the different cases they've had. I don't know of any lawyer that doesn't make a motion and ask for a physical hearing because they know that's the only way they're going to get a decision in Montgomery County.
I think there are some, it is very, very rare.
How would they get a ruling from you in that case without having to appear?
Without having to appear, it would be, there are a limited set of circumstances. Obviously, anytime a party wants to have a motion, they have a right to have time in front of the court if they want it.
Well, they want a ruling,
Right.
with or without the showing up. How would they get a ruling without having to then appear? And the other parties agree with that.
If all the parties are in agreement to do something by written submission, I'd be happy to hear it.
And how do they communicate that to your court?
Typically, they can email a court coordinator or call them on the phone and have a conference call. There are several really good judges in Montgomery County that will say, tell their court coordinator, let's schedule a conference call in this case with all these counsel. right now and see if everybody's in agreement, or they can do it by submission.
So now my question is, why is the judge looking at those opportunities? It's your court.
Right.
It's your caseload. Why aren't you looking for opportunities as to when you can make the process a whole lot more efficient? You look at it and you notify the other party, I want a written submission because I don't see any reason for all of y'all to come in. There's no witnesses that you need. It's a matter of law, no facts or dispute. Why don't you look for opportunities like that?
If it is a matter of law, things can be done on written submission like that. Both sides are asked to brief something.
I don't think can. I'm saying, would you as judge proactively have your staff look for opportunities to make such a ruling?
I would not have a problem doing that. Yeah, I would certainly encourage the opportunity.
Did that ever occur to you before I asked that question?
It does. It has. But I'm going to default to what I've seen in my experience, and it is very rare. But I have seen.
Yeah, why is that? Why is FaceTime such a criteria in courts?
That's a good question.
In civil courts.
I think it's a good question. I think the simplest answer is that it's been kind of the culture of how it's done. No, and that's,
no doubt.
And that's done. I think and the challenge for one judge doing that is that you'd be training
you're the only judge for that case.
For that case, but you're also dealing with attorneys that are in multiple courts.
Who cares what the attorneys think, really? The question is the right ruling going to be made? The worst they can do is appeal. And who are you disadvantaged? Not the parties, maybe the attorneys, but you're not disadvantaging the parties, right? You're saving them money because they have to pay the lawyers that show up and stand before you.
Yeah, I think there is probably more opportunity than is taken advantage of.
I guarantee you there is.
To do that, but it is difficult to convince everybody else that, hey, we're going to do that at this place alone.
You could do that as judge.
I hope to.
Most citizens prefer not to spend any time with judges,
Lawyers.
except jury duty. So they don't have a lot of knowledge of how courts operate, and every time we have an election, we always hear from the competitors how badly the courts run. Right. So what are some good measures that as a citizen we should use to judge whether we have a good judge on the bench?
Yeah.
Thank you for that question, because I have a saying that I've been trying to tell people about. You know how you have a good civil court judge? You forget they're there. Because that means business is quietly being done and efficiently, and cases aren't getting reversed on appeal. The judge isn't making decisions that are outside the parameters of the framework of the law, and so there is no reason or ability for the appellate court to reverse them. And so I would first, the most obvious measure is, what percentages of their cases come back on appeal? Now, generally, it's hard to win on appeal in a lot of cases, but if you're looking at, that's a tangible number, how many cases that judge has heard in a year, how many came back on appeal. So I'm an undergrad in economics, so the numbers, look at the numbers, that's a tangible way to look at numbers for one. The other thing is you could possibly, and I'm pretty sure you could have a district clerk track this, what's the average amount of time of cases pending in that person's court. Okay, what's the average amount of time, and this is probably a little bit more difficult, does the court spend between hearing evidence and rendering a decision? And so all of those things go to efficiency. And of course the appeal goes to the quality of the decision as well. Yeah, I hope that covered it.
So the court has a website.
Yes.
Right. So will you commit to publishing that data in a graphic form so that the citizens that go to that court can see that readily available?
I think certainly the average time a case takes from filing to resolution, certainly. I wouldn't have a problem putting that up. I also wouldn't have a problem with the number of cases or percentage of cases that get reversed on appeal. You can never control how many actually get appealed. The key is how many does the appellate court say, oops, the judge made a mistake here, that kind of thing. I wouldn't have a pushing putting those kind of numbers up there, I don't think, no. assuming the data is available to me. Yeah.
Dennis?
Okay, we're hearing that some of our judges, like Judge Bays and others, are knocking down the backlog and catching up with cases. So assuming they continue to be successful and you almost run out of business, and they say, we want your court to be 50% criminal or 50% family, do you have experience in those areas where that would be something that you could morph into?
Yes, my experience is civil and family primarily. I don't have a ton of criminal experience. I would classify my criminal experience as doing favors for friends that did something stupid. And so, I mean, and so, you know, I had a good friend of mine that was, you know, went to the Marines, got out, and was struggling a little bit, and got caught for a misdemeanor in marijuana. And so, yes, I helped him out on that, but stuff like that. But the Board of Judges would get that. The way I understand it operating, I've never been present for one of those meetings, is if they need a reallocation of where the case flow to courts, I wouldn't have a problem hearing family cases or any other cases that I felt comfortable with. I've done also some probate work as well. Ultimately though, this is intended to be a civil court, and I would have no intention of changing that allocation unless there was clearly citizens that we have way too many of X type of case and not nearly as many of these type of cases.
But that would really not be your choice, right? The Board of Judges would say, we need some more criminal courts.
It would be up to the Board of Judges. I think all the judges appear at that though, so there would be a voice. Yes, so it'd be only one voice, but I assume they work together like that. So.
I guess it could happen, but is it fair to say there aren't any criminal backlogs, right?
You know, frankly, I don't do much criminal work, so given that our population in 2010 was like 452,000 in the census, and I expect it to be over 700,000 next year, give or take. It's possible that there's a backlog in there as well, but I am not in the criminal court, so I can't really give you a good answer.
You don't want to be.
Yeah. I don't mind doing the simple misdemeanor stuff here or there, but I don't want to get into felony stuff where people are facing 20 to life, things like that. That's not my comfort zone.
We got about 4 or 5 minutes. You said you had a couple.
Just got a couple of questions real quick. Being the judge, would that be a increase or a decrease financially?
It would be a decrease financially with about 11 going on 12 years experience, and I hustle quite a bit. I'm not afraid to go to Harris County. There are certain attorneys here in Montgomery County that's just like, well,
Right.
I want to take the 15-minute drive from my house and that's it, but I get around to other counties as well. When you factor, as a solo, I don't have classic benefits. If you add in the benefits, the gap becomes less, but it'd still be it would be not an insignificant step back. So
Next question. I understand that this court will have responsibility, as all of them do, have grand jury responsibilities.
right.
Have you had any grand jury experience, or is that not a big deal? Or?
Grand jury is primarily a criminal thing. That would be something that I would have to learn on. That would be. Just be honest with the voter. I'd have to learn that portion of the job quickly.
Okay, that's all I got.
And what sort of salary do the judges make?
That was just a legislative topic, by the way. The base pay for a judge by the state of Texas is, for a district court judge like this, is $140,000 a year. The counties are able to supplement up to $18,000 more. I don't think Montgomery County supplements the full amount, but I think it's about $155 or so.
So you ought to be running for county judge, man.
The county judge, thankfully, as a citizen taxpayer, he did request a reduction in his pay this much time, and he still gets paid very well. But I'm very thankful that he and BD, they both did that.
I didn't know BD did.
I actually personally thanked them for that when I was at Westall. I personally thanked BD for that. I don't know if I've said something to Mark about that.
With the backloaded case management, I was going to ask you, what cases would you deem to have the lowest priority? What type of cases?
I think in my experience, I started off doing as an attorney writer for Social Security Administration, and you want to talk about backlogs. So the average date that those cases get heard. So if someone asks for disability benefits, they get denied. The average date they actually get a decision from a judge is usually, it's fluctuated, but it's usually 550, 560 days, 500 days. So it would go by. Number one, most priority would be the oldest cases.
Oldest cases?
Yeah. And
Well, what would have the lowest priority is what I'm asking.
the newest cases, but if you're looking for an actually
Well,
type of case.
yes, the type.
I would typically look at, that's a good question. I have not thought about that before you asked.
I'll give you a suggestion.
Sure.
Oh, we've already talked about them.
Uh-huh.
I'd say debt collection, credit card type cases for the simple reason that both parties went in with open eyes, credit reports, all assets, all that kind of stuff. There's already been a process for attempted debt collection, all of that. What's the rush?
Right.
Whereas if you have other cases that need more, why not push them to the back?
My gut reaction was going to say, like property cases or financial cases only.
Not mortgages. I'm just
Yeah.
talking about debt collection. It's just money. A person and a company.
And I think
Yeah.
that's a good suggestion.
Parties.
I also would, with that type of case, also really here emphasize alternative dispute resolution. Like if you can go to a mediator and you guys can come up with this stuff yourself and not take, the taxpayer resources to come to a resolution. Encouraging alternative dispute resolution would be an important thing for getting backlogs down as well.
Well, that means you have to hear that case first, right? I'm saying the ones you would put on the back burner before you take time to address them. Because you have to address that case, refer them for mediation.
Right. I don't.
Or you're talking about your staff would send out the letter saying, y'all go to mediation or something.
Typically, most civil cases, civil courts and family courts nowadays require a mediation or some form of alternative dispute resolution before they get to trial. And so it makes, but you can emphasize that particularly with certain types of cases as well. And I think an emphasis like that.
What's the success rate on mediation? That's my last question.
Ooh, it
That don't have to come to court.
That's, as a mediator.
More than half, less than half.
As myself as a mediator, it's well more than that, way more than half. In my experience, in your average financial dispute, I mediated this last week. I mediated an auto sub-row case. So, 2 insurance companies. One,
Well, that's 2 companies again.
I know, but
Yeah.
the matter was about a total of $8,000, and they settled it around 4. And so.
What a waste of time.
And in those types of cases, those settle at 80–90% in mediation or more. And the ones, and even more than that, settle outside of mediation because the mediation got them close, and then they were playing chicken a little bit, and ultimately neither one really wanted to spend all that time in court. So the day before, day of trial, they announced a settlement of some kind.
I got a quick, are there visiting judges in civil cases?
There could potentially be a visiting judge in any
situation.
Any court. That's the administrative judge, Judge Underwood, would appoint typically not a retired.
Judge Underwood,
Yes.
yeah, that's, so, TOMA, why is it so difficult to get a TOMA law, the transparency law to stand up to court challenge in Texas?
That's a difficult question.
You said a short question.
Yeah, okay, we can call quits. When you mentioned Underwood, he was the rule and run visiting attorney for that
Yeah,
case.
we got to wrap it.
Chicken,
All
coward.
right.
Who's a coward? Sorry, go ahead.
Who's that?
Underwood.
Oh, yeah.
Well,
That's a different subject.
when he gets to the visiting judges, he maintains a list of qualified retired judges that can sit in the place of judges, and typically he tries to get visiting judges that have family experiences, if they're family judges, criminals, civil assistants.
But they're all unaccountable. That's the problem.
There is an accountability issue there sometimes.
That is the issue.
That's what he
Correct.
said, summer criminal.
That's been-
It's something.
Yeah, let's go
Different
ahead and wrap it up,
context.
Chris, and, if you want, 25 minutes on your closing, and then
Okay.
we'll call it a wrap.
Well, I think I've without repeating the whole thing, maybe I'll get to a lawyer joke if you want one.
So where do you bury the lawyers?
I don't know, but you do it carefully. I think the main simple message I would say is that I feel like I'm as ready as you can be to do this job. And that's what it is. It's a job for the taxpaying citizens. And no one, and I discussed this with a couple of judges today, is no one is 100% sure until you're actually sitting in that seat. But I feel like my experience over a decade of civil litigation and the amount of time I'm in a courtroom, and in addition to that, the appellate work, I feel like I'm ready to do this job. That's kind of the message I would like to get to you guys and the voters out there, is that my experience makes me ready to do this. If you want that lawyer joke, I can give it to you.
All right. I will cut.
Okay.
Thank you very much.